Welcome back to If You Can Keep It, a podcast created by the Wisconsin Institute for Law and Liberty. In our last episode, we talked about the Supreme Court. We're actually going to talk about the Wisconsin Supreme Court, the shift in ideology, what's playing out in the state of Wisconsin. You know, Wisconsin, let's just say, has a unique way of selecting Supreme Court justices here in our state, and we're going to talk through some potential problems and solutions associated with that. So, Rick, welcome back. He's the president and general counsel of the Wisconsin Institute for Law and Liberty. We're also joined by Lucas Vebber, Deputy Counsel, Wisconsin Institute for Law and Liberty. He specializes in separation of powers cases, and he's argued in front of the Wisconsin Supreme Court a number of times. So these two are really the experts at litigation resulting in front of the Wisconsin Supreme Court. And so we're going to break down a bunch of cases today. So let's just jump right into it. SCOAS has been sitting on a number of lawsuits, or for the longest time, SCOAS has been sitting on an abortion case dealing with the 1849 abortion law. Rick, what did they decide? And when you tweeted about this, you said very clearly, and this isn't just about abortion.
Well, right. No, this is about the separation of powers. So the issue in call was what do you do with a statute that was originally enacted in 1849. It's been amended a couple of times in fairly trivial ways, but it essentially forbids all abortion except to save the life of the mother. Abortion after quickening, I think, is the term that it uses. Now, that law became unconstitutional after Roe versus Wade in 1973 and hadn't been enforced since then. At some point during that period, the Wisconsin legislature passed other statutes that placed limitations on the right to have an abortion that would be consistent with Roe. So, they would be you couldn't have an abortion after 20 weeks, but you could under certain circumstances. The question is, now that we have this old law and this other set of laws on the books, which one do you enforce? Now, one answer would be to say that they're both on the books, and they both can be enforced because the legislature did not, in fact, went out of its way not to repeal the older law. And the most reasonable inference there is that the legislature simply wanted to pass some limitations that would pass constitutional muster and could be enforced during the pendency of Roe, but they wanted to leave the older statute on the books for such time as Roe might be overruled by the United States Supreme Court, which has been a hot issue in constitutional law ever since I started law school, and that was a really long time ago. The court said, well, no, what we're going to do is we're just going to decide that this older statute, 90404, is simply about what we call non-therapeutic abortions. That is, it could apply if someone punches a woman in the stomach and causes her to miscarry. Then you could use this statute, but otherwise it's been implicitly repealed, at least as it applies to so-called therapeutic abortions, and we're just going to treat it as if it's no longer there. And the reason that this has to do with more than abortion is that it really goes to the way in which the court is going to interact with the legislature and its willingness to engage in flights of fancy in order to avoid enforcing statutes that it does not like. And I don't know how many times a situation like this is going to come across in the future, but it ought to have been the case that the court would have been guided not by whether it likes abortion rights or not. Chief Justice Karofsky had a long screed explaining why she does, but it ought to have been guided by legislative intent. And in a situation where the legislature goes out of its way not to repeal a statute, but to enact laws that are designed to comply with what was then the current federal constitutional rule during the time that of Roe versus Wade. The legislative intent, I think, is pretty clearly not to repeal 90404. Now, we may think that law is too harsh. We may think it goes too far. But the answer is to go to the legislature, not to run to the courts.
So, Rick, what's the lasting impression the court is leaving with this abortion decision?
Well, I think the lasting impression that's leaving in this, in many other cases, is that it is results-oriented. Now, I think we may have spoken about this in a past podcast where a layperson might not understand why, for lawyers, when you say a judge is results-oriented, that's a slur. That's a bad thing.
Because you mean results of results of a policy results,
right? Right. That the court is deciding a case based upon what it would like the policy of the state of Wisconsin to be. And the reason that that's a bad thing is because, as we've discussed before, we have a government of divided powers. Legislature makes the law, but it cannot enforce the law. The executive enforces the law, but it cannot make the law. The judiciary neither enforces or makes the law, but decides disputes about application of the law. And this division of power prevents it from being concentrated in one set of hands. It's a liberty-enhancing device. It's a consensus-promoting device. And when courts become results-oriented, they usurp the prerogative of the other two branches, and this is a bad thing. And that's why when a lawyer tells you a judge is results-oriented, that lawyer is saying that judge is doing the wrong thing.
Well, I actually think that's a perfect segue into another one of these cases that does deal with the separation of powers. And maybe in this case, we just talked about the Supreme Court of Wisconsin usurping power, but in some ways they acted to put more power into the hands of the executive. And so we're going to go to Lucas, who has been he's, by the way, got a stack of papers and legal cases and briefs that he's going to be wanting to dive into here.
The man comes prepared.
The man comes very prepared. Rick actually has no notes today, so I'm going to take the time to make a notice.
This is the prerogative of seniority.
Lucas, the 400-year veto. I mean, when he did this, when the governor Evers has line item veto authority, which he basically rewrote a tax policy for property taxes and basically created a property tax for 400 years. We're going to have Lucas kind of walk through what the governor did and then what this Wisconsin Supreme Court did in a complete rejection of separation of powers and basically empowered the governor. And then we'll probably get to Rick, because Rick's going to talk about how there's no permanent victories in politics and how this is going to come back to bite the other side. So, Lucas, go ahead.
So this case was called Lemieux v. Evers. It was brought to challenge a partial veto enacted by Governor Evers as a result of the 2023 to 25 biennial budget. I think to understand kind of how we got here, you need to understand a little bit about the history of the partial veto in Wisconsin. And so maybe this gets left on the editing room floor, but at statehood, Wisconsin's governor had one option. You could either sign a bill or veto a bill. You didn't get to line item veto the bill. And in the early 1900s, 1930 or so, the people of Wisconsin decided that they were going to give the governor a partial veto power. They gave the governor this power because there was this growing trend that the legislature was throwing everything into one big bill and forcing everybody to kind of vote on it. There were just a lot of earmarks that got added in. The idea was conceived as a good government idea to allow the governor to get rid of some of these other proposals that were included in the bill. Over the next 60 years, there were some back and forth as to what that power meant. Finally, in the early 1990s, the people of Wisconsin again amended the Constitution to prohibit the governor from striking individual letters of the budget of any appropriation bill, or from combining two sentences into one by striking words to combine two, basically to rewrite the laws. Now, the partial veto power only applies to appropriation bills, which is important here. there has to be an appropriation of public dollars for a public purpose within the four corners of the bill. Flash forward then to the 2023 to 25 biennial budget cycle. The governor originally proposed an annual increase in what they call revenue limit authority for school districts. So school districts in Wisconsin and municipalities in Wisconsin are limited in how they can raise taxes. For school districts, we limit their total revenue. We call them revenue limits. So what happens in that case is we tell them how much money they can raise from all sources, and then as the state increases state aid, it necessarily drives down property taxes in those districts. So when you increase the revenue limit, you're increasing the ability of local districts to raise property taxes indirectly. What the governor did, and that's different here than what's called a levy limit, which is just a flat limit on how much taxes could be raised by a municipality. So for school districts, the governor's budget proposed, I think, a $350 per pupil revenue limit increase in the first year of the biennium, a $650 per pupil increase in the second year of the biennium, and then going forward, he pegged that increased revenue limit authority to inflation going forward. That was the governor's original proposal. What the legislature did was they lowered that to $325 per pupil per year for each year of the biennium, and then got rid of the inflation indexing going forward. The governor used his creative line item veto authority to strike some of those years to rewrite the law so that it said for the 2023 through 2,425 school years, there would be a $325 increase in revenue limit authority. Thus, for the next 402 years, we're going to have a revenue limit authority increase and thus a property tax increase going over that time span. That veto was challenged for two ways under the law. The first thing that they said was that it was the governor was striking. Essentially, you can't strike digits. The same way you can't strike letters. It said that applies to digits. It was an original action that was filed with the Wisconsin Supreme Court directly, and they brought two claims. First, they said that the partial vetoes violate the Constitution because the governor did not veto the bill in part when he extended it to include 400 years. So it was originally a 2-year property tax increase, revenue limit increase. The governor extended that to 400 plus years. So the first argument was that. The second argument was that the vetoes violate the Constitution because the Constitution prohibits the governor from striking those individual digits to create new numbers. The court reviewed the long history of case law here related to the partial veto power in Wisconsin, which is a ton of back and forth. And there have been cases on this over the past, nearly 100 years now, trying to figure out what exactly this authority means. There's always a creative governor out there who has a creative veto. The people of Wisconsin respond to those creative vetoes with constitutional amendments seeking to cabin that authority. In this case, you've got Governor Evers with a very creative veto here to increase property taxes for 400 years. But the court concluded that the litigants, the claims that were being brought, they were not going to agree with. They said that the governor's veto of the 2 years to become 400 years was, in fact, in their opinion, part of the original enactment of the legislature. And then, secondly, they said that there was no restriction on striking digits because the Constitution itself only refers to letters, individual letters, and words from the budget bills, which this was not because these are actually digits, numbers, which are different in the court's mind. So, for those reasons, the court greatly expanded the governor's power here to make these types of vetoes. The legislature can respond in any number of ways. They could change the way they draft budget bills. They could also adopt a constitutional amendment again, which would change this. I think both of those are ongoing. Somewhat related to this, and shortly after the Lemieux case came out, we saw a second follow-up case, a unanimous case. This was Lemieux was not a unanimous case. It was 4-3 from the Supreme Court. Just a couple of weeks ago, we saw another case called the Wisconsin Legislature versus the Department of Public Instruction, which was a related case related to the partial veto power. This was a case where the governor used a line item veto power on a bill that the legislature argued was not an appropriation bill. And that's an important distinction here because the line item veto power only applies to appropriation bills. Here, the governor struck some things out of the bill. The legislature sued, saying that those vetoes were unconstitutional, and the court agreed with the legislature. They said that the bill that was passed did not include an appropriation of public dollars for a public purpose within the four corners of the bill, and therefore it was not an appropriation bill, and the governor could not veto that bill. That was an important distinction, just added some further definition to when the line item veto power could be used going forward, which I think is helpful for everybody. And then the second part of this case dealt with the legislature's ability to appropriate dollars to its Joint Committee on Finance appropriation, which is a way of kind of parking money for future use as they want it. And the court did also say that that met the confines of the Constitution. So a little bit of a pullback, maybe you could argue, from the Lemieux case to sort of try to right the ship of separation of powers a little bit. Interestingly, when the court talked about in the Lemieux case the partial veto power, they referred to it as almost a pseudo legislative power that the governor has. And I think that's the governor has a role in the lawmaking process, but the question becomes, does the governor have the ability to completely rewrite laws in ways that the legislature never intended?
Rick, talk about what it means for Wisconsinites if the governor, whether it's a Democrat or a Republican, has this massive line item veto power. I mean, I know, Scott Walker, previous governor, had some line item veto power. The legislature was obviously more aligned with him. But what does this mean going forward? Like, we're going to have new governors. We don't know who's going to be governor in 2026 or 2030. Like, why does this matter?
Well, so what I think I should do, Pat, is talk about the blues. And I wrote an op-ed in the Journal Sentinel about this, it must have been 15 years ago at least. And the title of the op-ed was Fattening Frogs for Snakes. This comes from an old blues song that was recorded by Sonny Boy Williamson, who lived part of the time in Milwaukee, and there should be a monument to Sonny Boy here in this city. Perhaps I'm going to put that on my bucket list to get a monument to Sonny Boy. But in any event, it's an old Southern phrase that talks about the futility that's associated with going to great lengths to do something, fattening frogs, and then having the output of your labor and the great care that you've taken away from you and dashed completely, fattening frogs for snakes, like the snake gets your frog. And so I think the biggest part of this is that the governor really doesn't have quasi-legislative powers. If you look at the Constitution, it says that the governor may approve an appropriations bill in whole or in part. And that suggests that, the governor can take out part of the bill and not approve it, but it doesn't suggest that he can reconstruct the bill by disassembling and reassembling its parts. If I had a contract with you, say I was an auto manufacturer and you were a dealer, and I had an obligation to make available to you a certain number of automobiles every year that you could take in whole or in part, it wouldn't mean that you could strip them down and stock your inventory department, your parts department with the pieces of these automobiles. That would be a very odd understanding of that language, and I think this is an odd understanding of the constitutional language. The other problem you have that Lucas alluded to is that the legislature now has to worry about what could the governor do to this bill that we're about to pass. Right?
Yes.
They have to role play this kind of acrostic game where they figure out, what smart kind of perverse thing could the governor do with his or her veto pen that would turn this into something else completely.
Because the line item veto is not meant for the governor to rewrite legislation. I think that's really important.
Right, and so now not only do you have the governor usurping power, but you distort the way in which the legislature exercises the power, because now, rather than simply writing an efficiently worded, easy to understand, effective bill, the legislature has to worry about writing in a way that will prohibit the governor from gaming it. There is no rational person, none, who would ever design a system of lawmaking in this way, and particularly since it's not compelled by the text of the Constitution, except in fact is contrary to the text of the Constitution. It is an amazing thing that the Wisconsin Supreme Court tied itself into knots, ignored the implications of a case called Bartlett that it decided a couple of years ago, a case that was brought by the Wisconsin Institute for Law and Liberty, which I think, although there wasn't an agreement on the precise standard to use, it essentially came to an understanding of the line item veto, as I've just described it, that it did all of these things in order to preserve this 400-year veto, which incidentally, we are not going to have this increase for 400 years, because if we did have an increase of $325 for 400 years, it would take about 8 or 10 years for schools to actually have less money than they have today, because that wouldn't keep up with inflation. And so, I mean, this was just I'm sorry, I think a petty effort by the governor to put one over on the legislature in a way which it will not have a lasting impact on schools, even if you think that they should have more money, and it is simply going to foul the law, aggravate the relationship between the legislature and the governor, and make it harder to fix this thing very shortly down the road, when it will become quite evident that this 400-year appropriation cannot remain in place.
I honestly think, I think the Supreme Court justices on the Wisconsin court might have completely missed the point of No King's Day.
Yes, that's right. In a case we're going to talk about a little bit later this morning, Justice Bradley in dissent said that apparently some people do not want kings unless the kings are of their own making.
Well, let's get into that. What case is that? Go ahead and talk about that.
Well, Lucas, this is your bailiwick, so I'm going to let you do this.
So this case was called Evers v. Markline, or Markline 2, we call it. So this is sort of a follow-up on a different case, an unrelated case. This case dealt with some of the legislature's oversight power over administrative rulemaking. Admittedly, administrative rulemaking is a topic where when you bring it up at cocktail parties, as I often do, people's eyes glaze over and they fall asleep immediately. But this is a really important case, and it's a really important separation of powers case. So in Wisconsin, at statehood, the legislative power was vested in the legislature, in the Senate and the Assembly. Over the first 50 or so years of statehood, the Supreme Court zealously guarded that power and did not allow the legislature to give it away. Laws had to be complete in all of their forms, right? They didn't let agencies kind of fill in the gaps. As the kind of progressive era ensued, as agencies got larger, as the power of government grew, there became this desire, I guess, among some to let these learned elites kind of fill in the gaps on these laws. That ultimately led to this robust rulemaking power being granted to administrative agencies, both in Wisconsin and nationally, but Wisconsin was really a leader in this area. So the legislature would pass a law to solve a problem, and they'd leave it really, they just sort of direct agency officials to do what they thought was best, right? Now, the court has sort of allowed that to happen from a separation of powers standpoint over the years by saying so long as there are sufficient safeguards in place for the legislature to maintain control over the exercise of that legislative power, they were going to let it go forward as a matter of constitutional law. As part of that, the legislature created an oversight committee called the Joint Committee for Review of Administrative Rules in the late 1960s. That's a mouthful. Most people refer to it as JCRAR or JCRAR. But that committee is made up of both houses of the legislature, of both assembly representatives and senators from both parties. Sit on that committee. That committee is ultimately tasked with reviewing agency rulemaking actions that come forward. One of the powers that committee has is to temporarily suspend rules that they, for let's say they don't conform with legislative intent, or they conflict with the statute, or there's a list of statutory reasons why the legislature, the JCRAR, could suspend those rules. And as part of the rulemaking process, they have what's called passive review on every rule that's going to be published. So every permanent rule that the agencies write, they go through a full process. It comes to the legislature. A standing committee of the legislature looks at it first. So, for example, if it's an environmental related rule, it would go to the Natural Resources Committee in both houses. After 30 days, it then gets referred to the Joint Committee for review of administrative rules. That committee then has oversight over the rule, just to make sure that those agencies are exercising that legislative power lawfully. That's a long way of giving background on this, but we get to this case where the bureaucrats in Madison, many of whom don't work in office buildings anymore, they all work at home, don't like the idea that lawmakers are going to exercise oversight on the laws that these bureaucrats are writing. Ever since Governor Walker came into power, there has been an effort at the state level to return power to the people, to give the legislature more power than they've had in the past, to give them more oversight and control. And some of those, that only kind of worsened things, I guess, with some of the bureaucrats who don't like that kind of oversight. This challenge in Evers v. Markline, or Markline 2, was a challenge to 5 of those JCRAR powers to suspend those rules. They actually challenged them, interestingly, on separation of powers grounds, which is wild to me because, again, rulemaking power is a legislative power. And as Rick alluded to, Rebecca Bradley, Justice Bradley's dissent begins in her opening paragraph, says, "Progressives like to protest against kings unless it is one of their own making." So what they argued in this case was basically that the legislature's committee here has no ability to stop the power of the executive to write these regulations, which is really an incredible proposition here because what the court has effectively said is that, these agencies, which have really more power than the legislature now, so they can write laws, and the only way the legislature could stop these rules, which again have the effect of law, would be for the legislature to pass a bill and for the governor to sign it. Of course, the only way an agency can write a rule is if the governor signs that rule. So you're essentially saying the legislature's power is limited to convincing the governor that the governor was wrong when the governor approved a rule in the first instance. And tremendous separation of powers concerns here over that unchecked, really, authority now that administrative agencies have, and what this will mean long term. I think this case is a great unbalancing of our separation of powers as they've come to exist in Wisconsin over the past, several decades, and will have, long-term negative ramifications here in the years to come.
Wisconsin is one of a few states that holds elections for Supreme Court justice. We have 7 on the court. They serve 10-year terms. These are labeled as nonpartisan races. Anybody who's familiar with our elections out here would know that that's probably not the case. Rick, these aren't nonpartisan races. This has become political warfare. Why has that become the case, do you think? And really, what is going to be the negative ramifications of that? And I think we've kind of talked about it with some of these rulings today.
Well, the irony of this is the Wisconsin Constitution was amended around the turn of the 19th to the 20th century to move judicial elections to the spring. And one of the reasons that was given was that, we want judicial elections to be during a nonpartisan election cycle so they won't be infected by partisan fervor.
That is not what happened.
The death of that came, the complete final death blow came in 2020 when the justice for the Wisconsin Supreme Court was elected during on the same day as the presidential preference primary, arguably the most partisan day of the year. And so I think what's happened here in short is, Justice Scalia put his finger on it as he so often did. He said, look, nobody cared much about us judges when they thought we were just doing lawyers' business. But if we're going to do things like change the definition of marriage, decide whether there are abortion rights, fundamentally alter the way in which legislative districts are general. It's a long, long list of things that courts have kind of taken over. They've run school districts, they've run police departments, and all of this, I think, is related to the progressive legal movement, which is very influenced by postmodern notions and is concerned about the indeterminacy of language. Language could be interpreted so many different ways that, well, heck, we just think it could be interpreted anyway. And we should interpret it in a way that leads to the result that we want. When judges do that, they don't become lawyers, and they're no longer lawyers. They're no longer really judges. They're just policymakers of a different type. And if that's the case, then partisan interests are going to want to be heard. And that's why you have, tens of millions of dollars being spent on these races, because there is a perception, and it's not inadequate, that these courts are not simply enforcing the rules that have been made by the legislature or the decisions that have been made by the governor, but they're deciding, they are the prime movers on how we are to live together, and that is going to attract this type of intense partisan interest.
Well, it's exactly what is driving, I think, the discussion with redistricting. I mean, we had one side during the last Supreme Court race that said, this is our chance to overturn congressional maps. And we also saw new legislative maps in a previous SCOAS term, with the court touching redistricting so much, which is a very political process in its own right. So, I want to react to that. What can we do?
Well, I think the amazing thing about legislative redistricting is that, first of all, the court addressed this in legislative maps, Senate and the Assembly and Congress in 2022, and the composition of the court changed, so a new case was filed in order to basically have a do-over, which was premised on something that was present in maps for many, many years. Sometimes our legislative maps will have non-contiguous islands. In other words, there'll be a little part of a district which is non-contiguous to the rest of the district, and that happens when part of a municipality is non-contiguous to that municipality. So an example, I think, is Racine. Racine has, if I remember correctly, a golf course, which isn't subsumed within Greater Racine. It's a mile or two outside the city limits, maybe not even that far, and so that gets put in with the rest of the legislative district. Now, that has been tolerated by courts for years and years and years, but this time the court used it as an excuse to redo the maps completely. And when it was redoing the maps, it said, okay, but we have to look at political balance and political outcomes, and it didn't really define what that was. But the experts that it hired, I think, took the position, and I don't think I'm mischaracterizing what they did at all, that the map should be drawn in a way that the outcome of 99 different legislative races in the Assembly, 33 in the Senate, most closely match the partisan outcome in statewide races.
And that's so crazy because, and we're going to get into this in our next episode of If You Can Keep It, we see the political boundaries of people, demographic boundaries, let's just say, or demographic makeup of the political parties is changing. And it's like, how could you possibly create a legislative, which are specific geographic boundaries? Like, how could you get that to ever mimic an election? I mean, it's a moving target.
You shouldn't even try.
You shouldn't
because
try.
It is it is an anti-constitutional value, because if you look at the Wisconsin Constitution, it provides for single-member geographic districts that are contiguous and compact. There is no reason to think that the partisan outcome of those races would match the partisan outcome of a statewide race. They would match only if partisan voters were evenly distributed throughout the state. But we know they're not. We know that they tend to be concentrated, and in fact, Democratic voters are more concentrated than Republican voters, and that means when you have a system of first-past-the-post, single-member geographic districts, Republicans are going to do better in the aggregate of those races than they are in a race for a single statewide office. I mean, I used to teach election law. It's one of the first things you do when you get to redistricting is you use stars and circles to show how the outcome of legislative races will be affected by where partisan voters, the stars and the circles, live.
Our last segment, we always do an off-the-cuff question where we try to stump Rick with something. So Rick, the question I have for you, we just saw Elon Musk was involved in the Wisconsin Supreme Court race, and he gave this lottery for $1 million to people who signed up to vote. Would you have taken the money, and if not, why not?
You are positing that there's any circumstance not involving a felony committed by me in which I would turn down $1 million. Now, there might be circumstances like that exist, but I'm not sure right now. I'd have to think about that for a while. I haven't really analyzed whether or not he was running an illegal lottery. That doesn't move me very much. I think that they initially put out some publicity that suggested that this was a reward for voting. That would make it illegal, but then they made clear that that wasn't it, that it was basically just a lottery. And I think the whole thing was dumb. I think the whole thing just sort of degraded the process. But on the other hand, I don't think Elon should be doing a perp walk, and I don't think whoever got the $1 million should be doing one either.
All right, well, thanks everyone for tuning into this episode. We'll see you all next week. A reminder, you can see our full schedule, see where we have this podcast posted at will-law.org/podcast. So thanks so much. We'll see you soon.